Hi everyone. Thanks for joining us today, and thank you, Nadia, for speaking. It's great to have you. Nadia is passionate about employment law. It's the perfect nexus between business, law, and people. She enjoys representing both employees and employers in all aspects of the employment relationship. In particular, Nadia enjoys advocating on behalf of employees and positively impacting their working lives, as well as providing proactive, strategic advice to employers to ensure they're complying with the law and minimizing liability. There's nothing more fulfilling for Nadia than building strong relationships with clients through empathy and understanding, helping them navigate through complex workplace problems and obtaining the best results possible. This is what motivates Nadia to be a trusted advisor and a relentless advocate. Thanks again for your presentation today, and good luck.
Thanks for having me, Alex. So today I'm going to talk about a hot topic, COVID-19 vaccinations and the workplace. A lot of people, employers and employees alike, are scratching their heads wondering if an employer can mandate vaccines in the workplace. And what happens if an employee refuses? Can an employer discipline or dismiss an employee if they refuse to get vaccinated? I will be addressing these common questions. So first, let's talk about whether employers can mandate COVID-19 vaccines. The short answer is, as always, it depends. Employers do not automatically have the right to mandate vaccines in all circumstances and to all employees. And currently, we don't have any legislation that's been released by the Ontario government to mandate that employers can mandate vaccines. Rather, it would have to be a fact-based analysis, depending on various factors, such as the nature of the workplace. So for example, if let's say there was legislation stating that employees in certain sectors have to be vaccinated in order to continue working in the workplace, then a different standard would be applied than in a situation where there's no such requirement and employees have been using alternative safety measures and are able to operate in that manner. What employers would have to do is to maintain a balance between health and safety concerns and privacy concerns. In addition, human rights concerns may be at play as well. So what employers would have to consider is, does the employee have a legitimate medical need that requires accommodation under these circumstances? Does the employee have a religious belief which prevents them from getting vaccinated? If yes, then an employer will have to consider accommodation options, and they will be required to accommodate the employee up to the point of undue hardship, which is a relatively high threshold to meet. So that's just a brief overview of the main concerns that employers would have to take into account. But I'm sure your question probably is, what should employers do in these types of scenarios? Now, the interesting thing is that this is all relatively new. So courts haven't ruled on whether non-unionized employers can mandate COVID-19 vaccines, or at least they haven't ruled at this time yet. But there is case law relating to influenza. Arbitrators in Canada have previously found policies to be reasonable where such policies didn't force employees to get vaccinated, and the employees could stay home with pay as an accommodation. There have also been an assessment of vaccinate or mask policies in the healthcare context. And in that context, what employers or what arbitrators have found is that such policies are unreasonable because there was limited evidence on whether masking effectively prevented the spread of influenza and whether asymptomatic individuals could spread it. Recently, we also had case law relating to mandatory COVID testing in a retirement home context. And in that context, employees who refused such testing were placed on unpaid leave as accommodation. And the arbitrator found the policy to be reasonable based on the dangers of COVID-19. So in a unionized context, arbitrators would look at collective agreements to determine whether or not such policies are reasonable or unreasonable. But in the non-unionized context, there are no such agreements. And in the absence of contract or policy stipulating otherwise, there's no collective agreement that an arbitrator would be looking at. It's likely that non-unionized employers can require employees to vaccinate in at least certain contexts. So, as noted earlier, employers should not think they have an automatic right to mandate vaccines. Generally, there would be a few factors that are going to be considered in the assessment of whether or not an employer can mandate COVID-19 vaccines. So, the first thing, which I'd noted earlier, is the nature of the workplace. So it may not be justified where employees can work remotely, or let's say the workplace is large enough to allow proper physical distancing, etc., and other safety measures. But it may be justified where employees are physically required to work from the workplace and can't work remotely, and they're unable to physically distance, and or if they're in contact with vulnerable populations. The second thing that's likely going to be considered is the availability of the COVID-19 vaccine. Obviously, where it's available and the employer is expecting that employees are going to get vaccinated, the standard would be different than where the vaccine isn't as readily available. So it's also going to depend on an individual's current situation. The third factor that's going to be considered are privacy considerations, and this is something that's going to vary based on the nature of the workplace as well. But generally speaking, employers should keep in mind that when they're asking an employee about vaccination and requesting proof of vaccination, that means that they're asking to collect personal information, which would trigger privacy considerations. And what we recommend as employment lawyers is for employers to consider implementing a policy that allows the employer the authority to collect such information, indicates what the purpose of collecting such information is, that the overriding health and safety concerns of its workers, for example. They should also specify, what's going to be required. If they're asking for proof of vaccination, are they asking for just a signed documentation from the employee confirming that they received the vaccination and just doing so on a trust-based system? Or are they asking for a certificate from the employee which states that they have received the vaccine? It should also indicate how they're planning, how the employer is planning to store that information. Obviously, in terms of making sure that privacy rights are not violated, or it's being dealt with in a minimally intrusive manner. It's going to be helpful if the employer can designate one representative at the company who's collecting and using such information. And it's not necessary that other people within the workplace or even outside the workplace, they don't really need to know who's getting vaccinated and who's not getting vaccinated. And if in a situation, let's say an employee is not getting vaccinated, they should also indicate what the next steps are going to be under those circumstances. Now, the fourth factor that's going to be considered is human rights, and along with that, it's the potential need for accommodation. So if a policy is being prepared at the workplace relating to mandatory vaccination, an employer needs to consider and recognize that the employer might be inadvertently breaching the employee's human rights under the applicable human rights legislation. So in Ontario, we have the Human Rights Code, and currently there's not, we don't really have a whole lot of case law on whether such a vaccination policy would violate an employee's human rights under the code. However, what an employer would need to consider is whether or not it's linked to one of the protected grounds under the code. So let's say in one case, an employee simply has a preference to not get vaccinated, but it's not based on a disability, let's say, or a religious belief, or some other medical need that the employee might have. So for example, let's say they currently take medication, which they're required to take because of medical condition, and the vaccine's going to interact negatively with it. So their doctor has recommended that they not take the vaccine. So those types of scenarios. Unless it's a scenario where one of the protected rights, protected grounds under the code are triggered, and the most common ones in this type of context would be disability or religious belief, then the employer is not really going to have an obligation to accommodate. Obviously, the employer can still choose to accommodate the employee's preference if they want to. For example, if they value the employee and they're concerned about employee morale, and let's say the employee can work from home in the interim, or be separated from the rest of the workforce, depending on how the office is designed, or maybe it could be accommodated in some other manner. That's going to be a separate issue to consider. But if it's not, and if you're just concerned about what the obligations would be, then under the law, there's no legal obligation to accommodate an employee's preferences. What an employer is legally obligated to do is to accommodate an employee's legitimate needs, and in the context where there might be a disability, for example, that's preventing the employee from getting the vaccine, and it's not simply based on a preference, you can ask the employee to provide medical documentation supporting the need for accommodation. You're not entitled to ask for what the diagnosis is or the employee's entire medical file, and there will be certain limits that are imposed. But the accommodation process is going to be a two-way street, and what you want to do is make sure that the employer asks for the information that they need, but the employee as well has to participate in the accommodation process. And the key with respect to such a process is to make sure that everything is properly documented, because if, let's say, the employee were to allege a failure to accommodate or a breach of the employee's human rights in the future, you want to make sure that you have the proper documentation that you need to show that you accommodated the employee in an appropriate manner and all the steps that you took to do so. The other factor, so the fifth factor that should be considered in this type of a scenario, it's more from the employer's perspective and from a practical perspective. Employers should consider how implementing a mandatory vaccination policy is going to impact the workforce from an employee morale perspective. And this is something that a lot of employers will be concerned about, but from a legal perspective, it's not going to have much of an impact. But from a practical perspective, this is something that all employers should consider, because when you're working on running a business, you want to make sure that employees are not suddenly demotivated. And if you don't need to implement such a policy in order to protect the workers because of the nature of the workplace, then you might consider whether or not it's going to have a damaging impact on employee morale, and if so, whether you really need to implement such a policy in the first place. Now, I know that was a lot, so I'm going to just check to see if there's been any questions or concerns from anyone here. So I don't see any questions yet, so I'm just going to keep going. But feel free to send in your questions if you want, and I can address them at the end. Now, in Ontario, the Occupational Health and Safety Act requires employers to take steps that are reasonable to ensure the safety of their workers. So the employer will need to consider that obligation and how they can fulfill that obligation. In most contexts, the employer doesn't need to implement a mandatory vaccination policy to show that they took all the steps that are reasonable to ensure the safety of its workers. But in certain contexts, so for example, in a healthcare context, it might be considered to be a reasonable step that employers are expected to take into account. Now, one of the questions that a lot of employers are going to have is whether employees can be dismissed if they refuse to get vaccinated, or if they can be disciplined if they refuse to get vaccinated. Now, again, this is going to depend on the context of the workplace, and before you take any action as an employer to discipline or dismiss an employee for any reason, but especially in this context where it's very novel, it's a very novel situation, you want to make sure that you seek legal advice, because you might be inadvertently breaching the employee's rights, and or failing to fulfill your legal obligations, and you could be exposed to potentially significant liability. So you want to make sure that if there has been a refusal, you don't just automatically proceed with discipline or dismissal, but you try and find out, what is the reason that the employee is refusing the vaccine. If it is triggering one of the protected grounds under the Ontario Human Rights Code, for example, then, as I said earlier, you would have to go through the accommodation process. You don't want to dismiss any accommodation request out of hand. If, let's say, an employee makes a request and you believe that it's based on a preference, but you don't really go through the process of inquiring as to why the employee is refusing to get the vaccine, that's unlikely to be sufficient. If, let's say, the employee later alleged a breach of human rights, it's going to be difficult for you to establish that the reason for the discipline or dismissal was entirely unrelated to the employee's disability, for example, or that you accommodated the individual in accordance with your legal obligations. So it's important that in that type of a scenario, you make sure that you inquire as to the reason why the employee is refusing the vaccine. And obviously, if it triggers one of the protected grounds under the code, then you're obligated to go through the accommodation process. But let's say the employee is simply indicating a preference with respect to whether or not they can get vaccinated. And in that case, there's no legal obligation, but from a practical perspective, you will have to consider, are you going to be providing some sort of accommodation to this employee? And is that even possible in the context of your workplace? And if not, what type of action are you going to take? Are you going to discipline the employee? Is there a need to dismiss the employee? And with respect to the policy itself that you have within the workplace, obviously, with respect to that as well, it's important to get legal advice. And even if you draft the policy, you want to make sure that you get it reviewed by an employment lawyer before you proceed with implementing it. But the wording of the policy should be very clear. And you don't want to put yourself in a tight spot with a policy that's too rigid, or on the other hand, a policy that is way too flexible and it's not really clear what is allowed and what's not allowed, and if employee does refuse, what could potentially happen. So you can have you can indicate in the policy that refusal under certain circumstances, may lead to discipline, or even dismissal. But if you, let's say, word it in such a way that refusal will automatically lead to dismissal, now that's going to be problematic, because you are going to have trouble implementing that in every single case, because obviously other could be relevant in determining whether or not dismissal is warranted under those circumstances. So, for example, in one scenario, perhaps an employee is unable to follow through with the policy because they have a legitimate need and they require accommodation. And in that case, you're not actually able to dismiss them or even discipline them for failure to get vaccinated. So you're actually not following through with your own policy. And if you can't show that you are implementing your policy in a consistent manner, then it's going to be very difficult to enforce it consistently. So you want to make sure that the wording is proper, and also that the policy itself is implemented in a consistent manner. And if you are, if there are certain employees where, depending on the nature of the workplace, it is necessary for them to be vaccinated in order for them to continue working, then you want to make that clear. Now, in a situation where, let's say, it's difficult to physically distance within the workplace versus a situation where your employees are working remotely, there's going to be different standards that are applied in terms of whether it's reasonable to impose discipline or dismissal. But where, let's say, the employees are going to be interacting with vulnerable populations, and you make it very clear that vaccinations are going to be mandatory given the nature of the workplace, then you might be able to justify letting go of the employee. Obviously, it's going to have to be assessed on a case-by-case basis. So I don't want you to think that it's an automatic right that you have as long as the employee is interacting with vulnerable populations, but it's more likely to be justifiable in that type of context. Having said that, dismissals in Ontario can be with or without cause. So the question is going to be, does the employer have just cause to dismiss an employee in that context? And as we all know, it's difficult to meet that threshold of just cause. It's not impossible, but it is a very high threshold to meet. And it is a contextual analysis when it comes to just cause for dismissal. So you want to make sure that before you take any of those steps, you seek the legal advice that you need. If you wanted to terminate an employee without cause, obviously the obligations would be triggered with respect to severance. If you have properly worded and implemented contracts in place, then you would be able to rely on those contracts to limit the employee's entitlements upon termination. But if you don't, and if their entitlement is based on the common law, then their entitlements could be significant, and you could, end up dismissing an employee and not necessarily knowing that you're going to be exposed to potentially significant liability. So just to give an example, let's say under contract, you're limiting an employee's entitlements, and to the minimum under the statute. Their entitlement could be limited to, let's say, 8 weeks, 8 weeks of pay. But under the common law, their entitlement could be up to 2 years, depending on all the relevant factors. But 8 weeks versus 2 years, obviously that's a huge gap. So you might be thinking that you owe the employee only 8 weeks, only to be served with a demand letter from the employee's lawyer saying that they're entitled to 2 years of pay. So you want to make sure that before you take those steps, you actually seek that legal advice and implement the proper documents within the workplace to protect your rights going forward, and maximize the flexibility as well. Now, one of the questions that we have received is that what about constructive dismissal? So a constructive dismissal is when an employer makes a substantial change to a fundamental term of the employment agreement or the employment relationship, and the change is made in a unilateral manner. So if, let's say, you require an employee to get vaccinated and the employee agrees or accepts it, then there's no question about constructive dismissal because it's not unilateral. It's a change that's been implemented. But the question is, if, let's say, the employee doesn't agree, could the employee allege constructive dismissal in that context? And given the COVID-19 pandemic, the employee would likely have to show that there was a concern that was overriding the health and safety concern. So again, we're going to have to come back to the nature of the workplace. But that is something to consider. We obviously don't have case law on this point yet, but you could potentially have an employee alleging constructive dismissal if you're requiring that they get vaccinated in order to continue their employment with the company. It's obviously a different scenario if, let's say, you're able to accommodate them by placing them on an unpaid leave of absence, for example. Now, I did notice that we received a question. So I don't know if Alex, you wanted to read it out, or if you want me to go through it. Okay, so I'm going to go through this. So thank you, Pooja, for your question. So the question is, can we have a policy which says that vaccinated employees can be without mask, but those without vaccines need to be masked and follow social distancing? So I don't know what context this is in, and what the nature of the workplace is like, but assuming that it is a workplace where you need to be concerned because the employees all have to work physically in the workplace, not really able to work from home, for example, that in that context, if you're implementing a policy where vaccinated employees don't have to wear a mask, so fully vaccinated employees don't have to wear a mask, but those who are not fully vaccinated need to follow other protocols, it has to be based on what the evidence shows. Okay, so this is manufacturing and office place. So this is a situation where, presumably at least those who are working, let's say in the warehouse, they're going to have to work physically. So you can implement such a policy, but you want to make sure that it's worded carefully and it's implemented in a consistent manner as well. The problem is that there might be some pushback from employees because we don't have enough evidence at this point, or at least some may reasonably argue that there's not enough evidence at this point saying if you're fully vaccinated, you don't have to wear a mask, because we still don't have research conclusively showing that as long as you're fully vaccinated, you can't transmit COVID-19. So obviously this is going to change over time and over the next few months, we might have more information that kind of guides this. But there might be some employees who kind of push back and say, well, you know, I'm concerned about my safety because I'm immunocompromised, and I want to make sure that employees, even when they're fully vaccinated, are not coming into the workplace without wearing a mask, because what if they can transmit it? So if it's a situation where you know, the vaccinated employees are not wearing masks, but they're still required to physically distance, then it's likely going to be seen as being more reasonable than simply implementing something at this time where it's without mask only, without any requirement to physically distance as well. So I know we're almost have 1 minute at the moment, so I'm going to see if there's any other questions or concerns. But if you, so I just received a message saying, thanks a lot, this is very helpful. You're very welcome, Pooja. If you have any further questions, feel free to reach out to me. My email address is nadia@rudnerlaw.ca. That's nadia@rudnerlaw.ca. You can also check out our website, rudnerlaw.ca, and you know, we publish and write very frequently on various employment law related topics, so you can find a lot of information on there. And obviously, if you need to talk with us directly, you can reach out to us via email or phone. So thank you so much, everyone, for joining in today. We had quite a lot of people tuning in. I hope this session was helpful, and you know, I hope you have a great weekend ahead. And obviously, any questions, feel free to reach out to me. Take care.